inherently difficult task, but the practical guide I would give practitioners is firstly, you've got to isolate out the needs of a particular plaintiff. So if you are the plaintiff's lawyers, you need to work them out and you need to quantify them and you need to put them in an affidavit. But as a practical matter, once they've been quantified, you then need to, whether you're for a plaintiff or a defendant, you've got to look at these kind of factors. You've got to look at the size of the estate. You've got to look at the particular needs that the actual deceased was under a moral obligation to provide for. Sometimes it's easy. If you're dealing with a really large estate, and if you're dealing with a widow or a spouse type applicant, it's really a matter of mathematics. You work out the cost of accommodation and you work out the costs of maintaining someone. And if there's enough money in the estate, that will virtually give you a quantification. The hard cases are the adult children cases, where there is not enough in the estate to meet all of the claims on the estate, and where you have to make a value judgment, or what one judge described as a multifaceted judgment, and you have to come up with a figure. And the figure really has to represent an amount which will be a capital advancement for the particular applicant, taking into account the needs which have been articulated in the affidavits, and which also takes into account the competing needs and moral obligations owed to the beneficiaries. And as a matter of practicality, I do a list. I do a list of saying mean, average, generous. You work out a figure in each of those three ranges, and then you look what effect it will have on the beneficiaries, and you look at the decided cases. That's, I think, a useful practical rule of thumb.